So let's talk a little bit about liens. I decided to do a lien thing. Someone asked me to do it after one of my seminars last year, and it's kind of the thing that you don't really want to. I don't know. It's kind of the step system. I don't know. You kind of don't want to deal with it, but you kind of have to, because liens are in every case. Okay. It used to be that when I first started out, and I've been doing this a long time too, it's kind of like the afterthought. But now, liens sometimes are the main thought. And there's we have some very effective ways to deal with liens, and very effective ways to try to resolve those. There's a variety of different kind of liens. So I have material in every kind of lien and every kind of way to resolve them. What kind of liens do you guys deal with mostly? Medicaid,
Medicare,
healthcare, hospital. All right, so they're all different, right? So, and in every case you're going to do it. So what I do in every case. So let's say. Let me just give you a hypothetical, not related to anything. Let's say your kid goes to your friend's house and breaks her arm on their trampoline. And then you have a claim like that. Well, and then you have medical care from your kid for your child, and then you may have health care coverage covering that. And then you may have and so your medical care may pay some, you may have some medical liens, or maybe a variety of different liens, and you make a claim. Or let's say there's an auto case, and your client may have health insurance, or also may have medical liens too. Or you also have folks who have no medical insurance at all, and all their care comes through the doctor's bills and a medical lien. Let's say you have MedPay. Sometimes you may have Medicare or Medicaid. So there's a variety of liens. In every case, I keep an orange lien file in my folders, and everything on lien goes into that one file so that I identify it and I know it. And so a lien, basically, as we know, is an interest in the case. It's a notice that actually goes to the defendant, not necessarily to you. We have a section in here on how to perfect a lien, and sometimes they're perfected and sometimes they're not. And what I try to do is identify the liens. I know what they are. I try to get them updated, and I try to negotiate with the lien holders and start visiting with the lien holders prior to final settlement of I took your book, Michael, and I gave it to someone when they came in, but we got more. So they have to perfect the lien with certified mail to the insurance company in order for that to be honored. A lot of times that doesn't happen, But when you get to a place where you're going to start sending out a demand letter, start talking to the other side, you want to start getting the liens together and getting the updated amounts. You'd be amazed how many times you think you have a $1,000 lien, and then you get the final bill and it's a $5,000 lien. You'd be amazed how many times you think you got a $5,000 lien, you call the person, it's a $200 lien because insurance came and paid later. So the bill that you have on the front end ain't necessarily the bill you have on the other side. You'd be amazed how many. So what St. Anthony's used to do for years and years and years is they would get health insurance to pay on the lien. They'd find out that there was a third-party case with an auto case. They'd pay the health insurance money back, and then they'd assert a lien for the whole amount to you. I see nodding going around, and some of the folks have been around. They stopped doing that. There was a series of suits. I tried to do a class action against St. Anthony's here, and I actually got some traction, had some plaintiffs, but then a couple guys had some verdicts in Kansas City. There was a couple big verdicts on that, and then St. Anthony stopped doing that because they have a contract. A hospital or provider cannot get paid by health insurance and then go after your client for the balance, because they have a contract with the health insurance company to accept a discounted amount for full payment on that, and they can't go after the person for any more. Your client is a third-party beneficiary to that client. So but that doesn't mean they don't try. So whenever you get that bill and you see insurance paid, adjusted off, boom, boom, and then they try to come over for the balance against you, or they play games with it. You'd be amazed how many times you get always get the medical right away. You get the medical right away, and then a year later you get another bill, and they're totally different. People are nodding, people see it. So then you'll see different adjustments, and they'll try to play games with that to try to get. But your client is a third-party beneficiary to that contract, and that hospital cannot go get any more money from you. And so in this material, I'm going to give you an outline of what I talked to you about, and then I'm going to give you the basic ways, the real good tricks that I know how to negotiate liens. So we got the medical liens where they have to, it's under the statute, and they have to put the other side on notice. They have to put the defendant on notice, the tortfeasor's insurance company. We have the hospital lien statute. I have a section on that about how to do it, how to perfect it, and then the lien reduction statute, which I use, and I'm about to talk about. Then we have the health insurance liens. Health insurance liens, if it's not an ERISA plan, they cannot take a lien in your case under the old Schweiss case versus SSM. A personal injury case is not assignable under public policy in Missouri. So if it's not an ERISA lien, they can't get the money out of your case, and they got to go after your client. If it is an ERISA lien, what you do is you make sure are you an ERISA lien? Show me the plan language where bless you, where it says you can get repaid. Tell me who the plan administrator is. There's a bunch of things you can do. I have appendices attached here about my ERISA letters and my other stuff. And then even after, yes, ma'am. Sorry?
The Supreme Court is actually, there's a case that was argued in March.
I got it in my material. So there's a recent, I hear you. So there's a couple cases. They'll send you the letter, and they always cite the first case. What do they always cite in their letters to me? McCutcheon. Is it McCutcheon they cite? U.S. Airways? So they cite that, but there's also this Montanil case, which I think is the case that you...
I think it's Neville's.
I have that too right here. Boy, are we on? I'd say I was on it, but I think John wrote. No. Michael, our awesome associate Michael wrote this. The Neville's case is in here, and I cite it.
It's just applicable to government.
But for us, for ERISA, what they're going to assert our ERISA lien. They're going to say that we can't go to state court to address it. But there's many things you can do. And I also attach in the appendice, I have an article that I found that's very good on some other points. You want to ask for the reduction anyway. They still paid you. They still got your free lawyer to go get it. You want to look at the benefits they're saying are related to the case and what aren't related, because they'll often put in stuff that ain't related. So you go through the bill and you take out stuff, and then you still ask them for the reduction. And you say, I want a third reduction. They give you 10%. You say, okay. They say, you're going to take it? No, I understand you're at 10%. I'm going to leave this money in my trust account. And I ain't going to do anything. And that's fine. You got a lien. I didn't pay it to my client. And you write a letter to your client. You say, you have this lien with Optum. It's $10,000. They agreed to reduce it to $9,000. We're not going to agree to yet. We're going to keep this in our trust account. And then Optum sit there and calls you. And you say, nope. And then you'd be amazed what they take 6 months down the line that they're not taking then. But you haven't done anything wrong, and they're not going to go sue you in federal court over $9,000. The other thing you can do, and I've done this, and I have an example. I have the motion and the court order that I did in St. Louis County, where I went to a motion to adjudicate lien and adjudicated the ERISA lien, and I noticed them up, and they didn't come, and I adjudicated it by 50%, because it's my belief that the court has an inherent power to adjudicate liens in a case, and almost every judge will agree, and I do that all the time. And I did it. The example I have in here is I did it on a really huge lien, $1,800. But the reason why I did it was because the kid that I did it for I've known his dad has been repairing my cars since I was 16 years old. My mom knows him, and I know
how many cars you drove that needed repair.
We paid for that kid. We paid a lot of money for that. Gave a lot of money to that kid. No, his family is the salt of the earth family. They repaired John's car too. The great guys, and so I said, screw it. They give me a 10% reduction. We went to a motion to adjudicate lien. They didn't show up. I adjudicated by 50%. I sent them the check. They said, no, you got to pay me the old thing, McCutcheon, blah, blah, blah. I go, nope, look at this court order. I haven't heard a hide nor hair of them since, and I'm going to keep on doing it. I also have, yes.
And how would you bring them into, then you bring them
The
into
case was already pending. The
and can you just give them notice? Do you
Motion to-
serve
yep.
them by, or do you have to serve them by?
Nope, give them notice. Put them on the notice, send it in, boom, go in and do it. Yep, you don't need to serve them. There's cases in here. The court has inherent power to adjudicate attorneys' liens, all these liens. And if you got a chiropractor who's charging you
But they don't need to formally become
served, no. Nope. Now, and you, what about the chiropractor who charges $1,000 a visit and won't budge off it? You can do that too.
You and I talked about.
Yeah.
Remember that email?
Yep.
We'll talk about it.
So now remember, as hard as we fight I'm a big advocate for fighting as hard on the back end on the liens as you do on the front end to get the money, because the client doesn't care. The client wants to know how much is in their pocket. They don't care if you got an extra $1,000 from Liberty Mutual, or if you knocked an extra $1,000 off that $7,000 ER visit, right? They don't care. So that's what you can do, and I do that. Now, on the other hand, you got to balance that, because if that chiropractor only charged $100 a visit and saw your client 30 times and did great service to your client, you don't want to cut that guy because he really helped your client and he did great work. If the ER bill is only if the ambulance bill is only $500, that's pretty reasonable. Why cut that? So one of the things you got to do is step back and don't drink your own Kool-Aid too much on trying to put too much in your client's pocket, because you got to deal with what happens the next month when you want to send a client to that chiropractor, or you're dealing with these other liens, and and maybe it is fair if St. Anthony's has a $25,000 bill, they only get paid $5,000 by the insurance, and maybe the copay is $500 that your client never paid, and that carried on over years. Maybe your client should pay that $500. But remember, when you're negotiating and dealing with these liens, when you do your settlement letter to your client, where you have to do in every case, you can keep money in your trust account. You can let those liens hang out over time, because you don't want. I settled this case. I'm not in suit. I don't want to have to file a lawsuit just to reduce this lien. It's not worth it. But you can keep the money in your trust account, give your client everything, and then we write in our letter, we reduced all these other liens. We didn't reduce this one. We're going to keep this $1,000. Maybe this person will see the light down the road. I had a chiropractor call yelling at us yesterday because he wants $1,200. He saw my client 5 times. I think that's not fair. I sent him a check. I wrote him a letter, say, I'll pay you $600. He wouldn't do it. I sent him a check for $600. I didn't say payment in full and anything else. I said in the cover letter, I don't dispute the $600. It's the other $600. I'm going to leave it. And he called yelling at me. Whatever. So those are some ideas on liens. Okay. So let's talk about. Is everybody following me? Does anybody have any questions so far?
Yeah, I did.
Yeah. Art.
Now, you said that they have to send a certified copy to the defense.
Yes.
Right.
Not you. If you read the statute, it's not you. That's the interesting part.
So if they send me a lien, then it's not.
I did
perfect.
this with. I'm going to answer. Yes, you're right. So whenever whenever the defense calls and says, "What liens do you have?" Don't tell them. Say what I do. Not that I'm hiding it. I say, "What liens do you have?" Because I may have 5 and they have 2, and this literally just happened with Brown and James. I have never not satisfied a lien in 25 years. I'm not saying that. I have never had, if the lawyers who work against me know, and I say them, I settle the case and I say, listen, send me the release. Do you want me to, I'll protect and indemnify you from any and all liens. Do you want to put that in the release? And 9 times out of 10, they send me the release and the check because they know that I'm going to do that. Now, if they don't know you, maybe they'll say, you reduce the liens, you negotiate it down, you tell me the amounts. And there's still some people, I settled a case in Springfield where they said, you have to tell me the amounts or we're going to write you separate checks for everything. I said, okay, no worries, because we're going to do that anyway. We negotiated the amounts down to different amounts. I sent confirming letters to everybody. And then I sent him the letters and I say, cut the settlement drafts like this. Whatever way, it either go through my trust account or yours, it doesn't matter. But if you're an unknown quantity to that insurance company, they may have you jump through those hoops. If you aren't, they may do it the other way. But if you screw over the insurance company, they're going to red flag you, and then you're not going to have that ease of doing it down in the future. So you want to honor that. So let's talk about the lien reduction statute a little bit. Do you use that, Rob?
All the time.
All right. So what that does is, and so you don't need to stay. I'll give you permission to go if you need to. We're both wearing pink today. So there you go. So we have so there's different tactics to negotiate and reduce liens. All right, I call them and I say, you got a free lawyer, knock it off by a third. Or I say, listen, my client's damages, and these are only if it's true. The truth will set you free. My client's damages were $500,000. The insurance limits are $50,000 in this case. And so your lien of XYZ, my client took a reduction because of the policy, because of the caps here. My client took less than full compensation, so you ought to do the same. And they say, show me also. All right, here you go. So that's a way. So the lawyer's fee, that we're getting a lesser recovery, their bills are too much. You guys charge $800 a visit. That's ridiculous. You got to charge, you're not going to get paid by insurance of that. And then you also argue, you say, listen, insurance pays you a third, 33% on the dollar, 30 cents on the dollar. You ought to take that less from me. The other thing is sometimes these places have self-pay discounts. Big hospitals have this all the time. Utilize that. I throw a bunch of ideas and a bunch of arguments you can use when negotiating with these people, but you got to get involved. And if you're doing a bunch of cases, you got to systematize it. You got to train your people how to do it. So I have a how to negotiate liens worksheet that everybody uses, and I actually took stuff from this. So as part of the lien statute, there's also a section, .225, that says, I call it the cram down statute or lien reduction statute, that says that if you have all the lien holders, if you take the amount of the settlement, if you take out the attorney's fees and the expenses, and then whatever's left, it gets split half to the client and half pro rata distribution to the lien holders. And then it says in subparagraph 5 that that's their only recovery. They can't get anything more. They're limited in that. Illinois has a little bit different statute. I have it in here too, where it says you split between the hospitals and the doctors, and you do the same thing, but the client still gets half of the recovery. And then what I do is I send them a letter, and I say, here's the liens. And I have attached. I have 2 Excel spreadsheets that if you email me, I'll send them to you. Is that my amazing paralegal Casey made these. You put did I already give that to you, Nadeem? You put the numbers in and it calculates it for you, and then I attach it to the letter to the providers so that I'm completely transparent. Here's all the money. Here's my fees and expenses. Here's the balance. Half went to my client. Here's the other half. Here's all the other bills. Here's their pro rata distribution. You got treated just like everybody else. We ain't screwing you versus somebody else. And here's the deal. And you're completely transparent. And then you say under 225.5, you can't go after my client ever again. Because, and what we also do is, let's say I got a case where I have $25,000 in coverage, and I got $50,000 in bills, but I only have one lien for $50. So what are you going to do? Because there's not a lien, you can't cram that person down, right, under the statute. Here's what we do. When we talk about whether or not they've perfected the lien with the insurance company, if you're a plaintiff's lawyer, the one great gift you can give your client in that situation or in any other situation is to know these bills are done and they're gone. If you ever talk to your client, you're fighting this and that, and then you ever have them call, listen, all I really want is to have my bills gone and have a little bit of money in my pocket. I just don't want the stress of these bills. Okay, cool. I can do that for you. So a lot of times, so that gift of dealing with the liens, double down on those liens, gives them a great service, and they'll love you. You'd be surprised how many lawyers don't do that, and they don't want to deal with the liens. They want to take the fee, they want to do it, and they want to. So if they haven't perfected the lien with the insurance company, I say, it doesn't matter, you got a lien. And if I have a case where I have $50,000 in medical, I have a $25,000 policy and only a lien for $50, I write the other bill collectors and I say, send me a lien. I try to get them a lien, and I tell them I'm going to give you a lien. They don't know I'm about to pro rata reduce them, but well, you know what? They make a lot of money. So I make everybody give a lien, and then I say you gave a lien, boom, 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 and they're like, what? St. Anthony's, these other places do very aggressive behaviors too, and that way I know my client is protected. I will also say we have a case right now, and it's in the materials where my client. Long story, we settled this case, and United Healthcare had paid St. Luke's, but then 4 months later took the money back. And then we settled the case. And then St. Luke's asserted a $27,000 lien in my settlement. And United Healthcare refused to pay. And we appealed the denial through United Healthcare, and they said, you missed the 6-month appeal. And I said, well, I have the original bill. Remember, you always get those. I have the original bill showing you paid. And then we got a later bill when the lien was asserted, and they said, nope, we didn't know you took the money back. They didn't tell the client. They didn't do anything. So that you're between Scylla and Charybdis, to be fancy, or a rock and a hard place for you, Nadeem. And we can't appeal that. We're beyond ERISA, right? So we did a motion to adjudicate lien. We brought in St. Luke's. We brought in United Healthcare. United Healthcare never showed. The St. Luke's guy came in and said, we didn't send our original lien by certified mail, so we don't have a valid lien, so you can't use subsection 5 of 225 to say we can't go after your client. So we argued that. I hopefully will win. There's a lot of case law. There is not a single case interpreting subsection 5 of 225 in the state of Missouri. But I always say that you can't go after them individually, because it literally says it. The language says this is your sole relief. You can't get any other remedy outside of that. So the other thing we do is we fake it till we make it. What we do is when we reduce these liens with the lien reduction statute, we even put in the ERISA health insurance person. I say, you know what? Let's see what happens. And so people without liens, and I think you should do this, people without liens or ERISA, whatever, we put them all in, we pro-rata distribute it, we do the letter, and we say, hey, you guys are all reduced, boom, 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 we do it to my client, and then 99 times out of 100, they take it and don't do it. Because I'm not being too unfair. I mean, if I was trying to reduce $75,000 down to $1,000, they'd sue us, and that'd be a big deal. But I'm getting a marginal change. It's not worth it to that much. It's more important to my client. So I do all that. And in my settlement letter to the client, I tell them what I'm doing. I'm doing my best shot. They have a chance to challenge this. This may not work, but here's what we're going to do. And da-da-da-da. And sometimes I keep more money in my trust account, and I let it hang out there for a while. I see if all the checks are cashed, that kind of thing. So we do that too, and that's very effective. If it's a small ERISA lien, has anybody done that? No. Yes. Okay.
Yeah, I send them a letter, say pursuant to the lien statute, this is what you are entitled to, and this is issued in full satisfaction of my client's bill. And just a couple of weeks ago was the first time St. Louis used say, hey, we don't accept that, pay us the full amount. But usually they just accept it and it's no problem.
Right. What I tell all the clients too is I say I charge you a third of this or whatever percentage in this. I'm always your lawyer on this. That's part of my deal. I'll defend you on these. I'll always get your back on these. So that's something you can do. And it usually works. So even if I have liens from three of the five providers, I include the other two providers in the lien reduction statute. I say that's the deal. In the case with St. Luke's, I said they asserted that it's too convenient. They asserted a lien. We're here on a motion to adjudicate lien. That's their only reason they can have an interest in this. And as soon as they see that we have these defenses, oh, we don't have a valid lien. It's too cute by half, and it's not fair. And the court still has jurisdiction to do this. We think we're right on that. So that's kind of the long. I don't have any other real brilliance on that. Not that the other stuff was. The interesting issues, with this ERISA liens, these can be tough too, because there's a lot of bad cases. There's another case, and the case I thought you meant earlier that came out earlier this year again said you cannot use equitable principles to trump the plan language if it says no. You can't reduce that ERISA lien. So what happens is you'll have a case where your client, there's a $100,000 ERISA lien, and your client's getting $25,000, and you say that's not fair. Are you kidding me? And the cases all say, nope, sorry, you got to do it. But here's one thing you can do that I didn't mention. The reason why you sent a letter asking for who's in control of the plan and the plan administrator is that who makes the decision? Yes, it's with Optum, who is a company that's changing every couple of years. They buy each other. Now they're in Atlanta, but I think Optum's gone now too. But anyway, they get paid a percentage on what they recover. Okay, that's how they're in business. They don't give a hoot who the plan administrator is. So what I do is I cut out Optum and I go right to the plan administrator. We had a case where it was literally that. Our client had a traumatic amputation on the road in a motorcycle accident, $100,000 cap recovery. If you think that's enough to compensate someone for their lost limb, that is not accurate. The ERISA lien was over $100,000. I asked, who is the plan administrator? I went to them and I say, this is the plan administrator is your boss, is the company, and they had employed this guy for years and years and years, and they really liked him, and they were doing fundraisers for him. Yep.
Yeah, isn't the penalty still in place too? If you request the plan documents in the Form 550, they don't get it to you within a certain amount of time. It's like $50 a day.
That's a great point. Is it? Have you done that before, Sean?
I've threatened it. They usually end up getting the documents at the time. Derek had a case years ago. He was actually able to use that. He said, well, you took 120 days to get me this stuff, so that's $50 a day. Take that off there.
That's brilliant. That's smart. Derek Good, if you don't know who he works with, he's a state rep down in Jefferson County. But you go right to the plan administrator and said, I know you guys got this, but can you reduce it? Can you work with me here? Because I don't want to fight this out. Now, there are some places that will never do that. Carpenters Union is terrible for the plaintiffs, but every time I argue with them, they have a great argument. They say, listen, we're a union. Every dime we get from you gives health care to all our members. And, I get it, but you recovered from this third party, so why not help the other families of the carpenters who are working really hard? And it's a great argument, and they don't budge. And maybe 10% here. I've gotten 10% a couple times, but they're real sticklers to it. I appended in Appendix F is the motion to adjudicate lien in an ERISA case. I represented Cynthia Cooper. That's appended to, where I had a $76,000 lien reduced to $165 because I had the other thing, when I say talk about what is related to the case and what isn't, you really need to do that, especially in contested cases like med-mal cases or something like that, where the defendant comes in med-mal cases, half the time you lose those cases or win them on causation, not just breach of the standard of care. So my client had piles of medical, but it was all related to conditions, congenital conditions, long-standing conditions, not related to what I was saying. And especially if, even in your case, if you say this medical's related and the defendant comes in and says, nope, it ain't related, da-da-da-da, you take the defendant's letter or their expert or whatever. I've taken a defendant's expert's depot, sent it to the lien holder and said, we settled this case where we did because look how that defendant's expert was right. And so then you take that. So we were able to reduce that lien. And I got a firm in Chicago, and they were all sending me letters and stuff, but I picked up the phone and called the guy, and I talked turkey with them. We do all this stuff these days with emails and letters and stuff. You know what? pick up the phone and call someone. You get right to the heart. And that we had a great conversation. He's like, you know what? You're right. Tell you what, you send me this, this, and this. I'll take it to my client. Boom. Then he sent me a letter reducing it to $165. And he was right. And I said, look, the only records that are related, look at the defense. Here's the defense's response to my demand letter. They're saying only the ER records related. None of this other stuff is. And you know what? They're kind of right. So we kind of settled it. We have Medicare and Medicaid. People are a little bit afraid of Medicare and Medicaid. Everything you need to know to resolve that is in Section 5 of my materials, including the forms, the address, where you fax it, everything you need to do. What you want to do in any case, you have Medicare, and every release now has that. You got to send in the forms right away, and then you sit on it. Then we're ready to settle it. Then you do the rights and responsibilities letter, and then you don't have to request a conditional payment letter anymore. That comes automatically. Diary your file for 65 days after you send the rights and responsibilities form, and if you don't get it, then write them and call them. Have someone like my paralegal Casey, she calls these people, and they get it to you like that. You can, where is it? Pick up the phone and call them. You'd be amazed. Medicaid is a little bit different. That goes to the Missouri Department of Social Services. Here's their fax number. Here's their address. You do the same type of stuff. You have to give Medicaid a HIPAA there's other types of liens like child support liens. When I get a child support lien, I'm like, absolutely, I want to pay that because I want to help the kids. So sorry, client, I'm not reducing. You get half of the net recovery. That's what the child support, and I like to get it. But always get the last payout because the client is still paying on that past child support. Then you find out we just reduced one from $3,000 to $200. Workers' compensation liens. I have in Section 6 of our material a formula for filling in the blank, calculating work comp liens.
Yeah, Rudiger.
Rudiger. And it's not, but Rudiger is the old case. It's codified in 287.150, I think. Yes. And it's Rudiger. So you take the amount of the paid in comp, and then you get the ratio between that and what was paid in the civil. You take out your fees and expenses, and then that's the amount of the lien. If you have comp cases, you always settle the comp case first, and then you settle the civil case. But you can do a couple things. You can dump your expenses into the civil case, which will instead of the comp case, which will reduce the lien more. But the other thing is, think about, again, with these liens, with everything else, think about it beforehand. What I try to do is I try to take less in the comp case and have them agree to waive the subro. Sometimes I'm successful, sometimes I'm not. I had a case, I thought I was going to get it, they didn't do it, and so, because they want to pay me, offer $7,000 in the comp case, and their lien is $35,000, and the defendants have offered me $40,000, so we're in suit in that auto case. We'll end up settling. I've explained it all to the client many times. We're going to end up settling the comp case, and we'll just do what we can in that. There's some other nuances about there's a trick. If you got a spouse's loss of consortium case on the civil case, dump it in the loss of consortium case. There's a court of appeals case where they gave the injured worker $2,000 and the widow $166,000. That passed muster. All right, and then there's another thing about there's a Supreme Court case in Kapperman about comparative fault and some other issues about a casualty company, and then there's a new case out. It's two other issues: FIBA and attorney's liens. And then I'll let you all go, so you can go to the Cardinal game. Some of us lucky ones, us semi-retired ones. There's this And I have a couple of cases with federal employees. The U.S. Supreme Court just ruled in a case out of the state of Missouri, appeal from the Missouri Court of Appeals, where they basically said FEBA has the same power as ERISA. FEBA is the Federal Employees Health Benefits Act, and what they said is that FEBA preempts state law, and they get to come in and take back their lien money. Attorney's liens. I have all the statutes on attorney's liens and all of these issues. The attorney's lien statute's very interesting. It's a very old statute. Did you know that an insurance company is out? They have to get if they settle a case without first procuring the written consent of any other lawyers, they're liable to the attorneys for attorney's liens. So of all the lien statutes, the strongest ones that insurance companies have to worry about the most is attorney lien statute, because you can double dip on that. And that's why insurance companies should always get in protect and indemnify language. And you need to deal with it. If you get a case after it's been with another lawyer for a long time and they come to you, you got to deal with it with the other lawyer. And sometimes it can be done, sometimes it can't be. I always try to work it out with other lawyers. I have had occasion where I've had to litigate this because it really aggravates me when a lawyer sits on a case for 3 or 4 years, doesn't do squat, and then tries to assert some big fee when you're the one who came in, had to deal with a stale case, got a great result, and then that guy wants a fee where they did a disservice, because that's diligence and competence are the most complained of by 80% of ethics rule violations. And as plaintiffs' lawyers, that's what we get. Why is this taking so long? And that's the bad rap on lawyers anyway. And so there's some good law. So people think, oh, you get your hourly fee. And if you spent 1,000 hours in a case that settled for 10 grand, you should get that much money. No. What it is it's an equitable remedy. And there's a lot of cases that say you have to show the reasonable value of the services performed. And we all know already that if the contingency fee contract is terminated prior to the contingency occurring, that contract's gone, and then you have an hourly claim. But it still is an equitable claim subject to unclean hand latches, those equitable remedies. We've argued those before. Most judges get it, although I remember vividly arguing one time in front of Judge Durker, and I knew the other lawyer. I tried to be nice, but we argued, and I said, you can't go sit on a case for 3 years and come in and try to get a third of whatever was offered. That you just can't do that. And he just gave it to him. Oh, well. I have a lot of ethics rule, equitable stuff here. The ethics rule on fee disputes, we put it in here, requires you to consciously consider using a fee dispute committee. It's in the ethics rule. Go to the fee dispute committee. Lastly, I note there's informal opinion 125 that I also attach in here. A lawyer cannot guarantee the payment of a lien out of his trust account. Okay? Because the client, you can have the client agree to it. So if I settle a case, I'll say yes, the client agrees to satisfy liens, but the lawyer can't, and the lawyer can't out of the trust account. However, when I put this in here, John Burns, our associate, found a comment to rule. What was that, John? To rule
4-1.
I have it in here. We cite it in here. Oh, it's right away. I put it in the beginning of this. It's the comment to the rule, to the ethics rule, that says that you have. We found it in an article about that you have an obligation to pay good claims, and I don't know. I think your duties to your client, because your client may decide to blow off that lien and not pay it. And if he tells you to do that, I think you got to honor that. If they come after him, they come after him. But I think you owe the duty to the client, which was the point of that informal opinion rule. But the big picture here is, even though you can fight on whether or not someone has a perfected lien and all this stuff, I find that the better practice is to take all those liens in, whether or not they're good, they're bad, whatever. Take all those debts in and then resolve them all for the client. So as they're going forward, they don't have anything chasing them. They don't have anybody suing them later. You don't want to have to go defend them in the case. Take care of all the liens. Double down on the lien issue. Judo the lien issue. Take it in, embrace it, and get rid of it. And then your client loves you. And there you go. Thank you. Any questions?
Yeah, I got a question.
Yep.
Now, in terms of that Missouri lien law, my understanding is that after attorney fees and expenses, Medicare or Medicaid will come right off the top before the pro rata distribution between the healthcare
Yes.
plans. Is that correct?
Yes.
Okay.
But you can negotiate Medicare or Medicaid too. By the way, you call them up and they're nice people. They'll negotiate with you all the time.
Okay.
So you're saying that if you go pursuant to the Missouri lien statute, because I never thought that, in my interpretation of the statute, that Medicare or Medicaid factors into that. So you're saying that it does?
I think that
So if you settle the case for 10 grand, you got Medicare out here that's wanting $2,000 back. How does that figure into the formula?
what I would do is I would say the lien statute doesn't talk about it. And the lien statute doesn't talk about whether it's an ERISA health plan lien or another lien, doesn't talk about it. I would take that out of the amount and then give pro rata on the rest of it and see what they do. Because, I mean, it's got to come out, and it shouldn't come out of the client's part. So I don't know if you do it above the pro rata distribution or before you split it in half, or you do it
I'll
after.
with like the expenses and then that way, because they all have their own
Yeah, because,
formulas.
I mean,
They're very
take
similar.
the attorney's fees, take the expenses, take Medicare, Medicaid out, whatever's left after that, divide by 50%, and then do your pro rata reduction. But I don't think
What I
the
do-
statute says that.
What I do is I don't do it that way, because if you take the ERISA or the Medicare Medicaid and you put it into the half that's got to be divided, you give your client more money. So if it's a $2,000 Medicare lien, rather than taking the expenses, if you take out your fees and your filing fee, and then at a 10 grand case, let's say the client gets $6,000, rather than taking $2,000 out and dividing up $4,000, you divide up $6,000, you put $3,000, you divide it, that's 3 on each, you take the Medicare lien out of $2,000 out of the 3, there's $1,000 left for the rest of the people. Did everybody get the math? Yeah. I know I was doing quick. But you can also reduce Medicare and Medicaid and say we have these, I always, with Medicare, Medicaid, and ERISA, I say I have other lien holders, because they'll ask you. They'll say, who are your other lien holders? Here they are, da-da-da-da, then you work it out.
You can also file a lawsuit in Missouri to reduce the Medicaid lien.
You can, and that's in my material. The statute's here, and you can do that too. Yes.
Same fairness principle.
Thank you. But Medicare, I've never had to do that. They'll end up, I don't know.
I've done one.
Have you?
Yeah, and it's no big deal.
Okay.
I've had judges reduce them.
There you go. Don't be afraid to go do a little extra work to do that. Thank you.
I just got one more question.
Yep, you're good. You're
All
still.
right. Now, you had said if the client tell you to blow the lien off, then boom, go ahead, I'm just blow it off and they'll be responsible for it. But now if that lien is perfected, then you could be on the spot too, as well as the client.
But no, you can't be. That's not a loan. Now, that Liberty Mutual can be, and you can agree that the client indemnify Liberty Mutual, but not you as the lawyer. The lien statute, the Medicare Medicaid is different. Medicare Medicaid, you can be personally liable, but a hospital lien statute, that goes to the tortfeasor and his insurance company, not to the lawyer. There's nothing about the lawyer in the statute, and we set all the statutory stuff out here too. But you don't want to personally guarantee that lien and sign a contract to it, because then if you did that, then you can be on the hook. I don't think that's a good, and I've never had a client do that, to tell you the truth, but because I will always sit there and go, you don't want to do that. You want to get all these bills behind you. You want to be done. You want to go in the future, because they will go after you. It's going to kill your credit. What's the point? Why don't you let me we're in the you're going to get your best deal right now. I'm going to negotiate this down. They're going to take 50 cents on the dollar, da-da-da-da. Then you're done with it.
This might be slightly off topic, so if you want me to ask it later, I can.
Why don't you ask it, and then let's see if
Sure.
what the group energy is.
There you go. So I have a case right now. It's in Illinois. My primary practice is in Illinois. We have Blue Cross Blue Shields trying to come back for about $90,000. So it's a subrogation issue that we're dealing with. And Illinois has codified the made-whole doctrine in 2013, I think. So you have a statute, but there's no case law interpreting it. No one's really done anything on it. Usually it's done with a letter or so. I have a client never going to be able to run again, horrible ankle injury, $250,000 in policy limits. Clearly the case is worth more than that. And Blue Cross Blue Shield's trying to get $90,000. Under the statute, I think I should be fine, and I'm planning on filing a DAC.
I don't think that statute will affect, if they want to force it, they are not bound by the Illinois lien reduction statute. They're an
That's
ERISA
not the
plan.
lien reduction statute.
Oh.
There's a separate one now codifying the made whole doctrine.
Okay.
Against subrogation interest.
Right.
And it basically says if there's any limit on recovery due to limited insurance,
Right.
I think this would be the case.
Right.
That a judge is entitled to determine what the value of that case should have been, absent limited policy.
Okay.
Policy limits. And do it that way. So
Missouri needs that.
What's that?
Missouri needs that.
Yeah.
That's great.
It's a great statute, even though it hasn't been used that much just because it's newer. So my plan was to file it because they're just now budgeting off this $90,000, which I think is crazy. Hopefully they will after my most recent letter, but my plan was to file a DAC action on it, and I didn't know if anyone had sort of done something similar.
That or wait, because you don't have to collect the $250. Fine,
Right.
you guys are going to kill my case. My client, I've said this to lien holders. What motivation does my client have to settle this case to do it? Why would they go through 2 years of litigation to get nothing? Are you kidding me? We're going to let that die. In fact, maybe we'll do the depo and say that the defendant wasn't at fault at all, and I'm not injured, and screw the lien over. I mean, what are you going to do, right? I mean, what are you going to do? And you're their bill collector.
Right, exactly.
So I would, or you do a DEC action. I'll tell you, you do a DEC action, get the plan, and do a designee depo to the plan administrator, and start making them spend time and money to do it. They may change their tune.
Yeah.
Because you don't want to be unfair. They should get some money back, right? Maybe $45,000 off 90 or something. Give your client, give you your 25% fee and 20%.
Yeah, no, that makes sense. I just didn't know if anyone had dealt with it.
Until, as these guys, as some people talk about suing them, they can sit till the cows come home and write you letters and stuff. But as soon as you start suing them, file the motion to adjudicate lien, until the rubber hits the road and you're making them go do something, you kind of got to. And that's what these days, I file suit on a lot of cases because no one's paying, and you'd be amazed. You file a lawsuit, you get a new adjuster, you'd be amazed how they're going to pay you that extra $5,000 when they wouldn't otherwise. And what else are we here for, man? File suits and do this stuff.
For sure.
Anything else? Thanks for everybody for coming. We put in the materials. Thank you. Thank you.